Imagine being able to ask the ATO, before you sign anything, how exactly will you tax this? And getting the answer in writing, an answer the ATO is legally bound to honour. That tool exists, and it is called a private binding ruling. Used well, it is one of the most valuable instruments in Australian tax law. But there is a catch. Sometimes the answer comes back against you, formally, in writing, with real money attached. I am Tin-Lok Shea, tax lawyer at Australian Tax Experts. In this presentation we will cover what a private ruling is, when to seek one, how to apply well, and what to do when the ruling goes the wrong way, including a case where we had an unfavourable ruling worth $350,000 overturned entirely. 4 markers frame the topic. $0. What the ATO charges for a private ruling. The application itself is free. The real investment is in the drafting, and you will see why that matters shortly. 100% binding, on the ATO that is. If you carry out the arrangement exactly as described, the Commissioner must apply the law as ruled. 60 days plus, the minimum window to object to an unfavourable ruling. In many cases, the standard objection period for the year gives you considerably longer. And $350,000, the CGT liability generated by one unfavourable residency ruling issued to our client, before our objection had it overturned in full. Rulings are powerful in both directions. The skill is in handling both. So what exactly is a private binding ruling? It is a formal written decision by the ATO stating how, in its view, the tax law applies to a specific arrangement involving a specific taxpayer, you. Not general guidance, not a website answer, a ruling addressed to your facts. And the key word is binding. Once issued, the ATO is legally committed. If you enter into the arrangement as described, the Commissioner must tax it in accordance with the ruling, even if the ATO later decides its own answer was wrong. That is a remarkable form of certainty in a system built on self-assessment. But note the boundary. The protection attaches to the arrangement as described. Carry out something materially different from what the application set out, and the ruling quietly ceases to protect you. The facts in the application are the foundation of everything. When should you reach for a ruling? The classic pattern has 4 beats. First, a significant step is coming. The sale of a major asset, a business restructure, a move overseas, a transaction with real tax money riding on it. Second, genuine uncertainty. The law's application to your particular facts is unclear, contestable, or turns on judgment. Residency questions, main residence exemptions, trust arrangements. Third, and this is the crucial timing point, you apply before you act. A ruling obtained in advance lets you shape the transaction around the answer. A ruling sought afterwards can only tell you how bad the news is. And fourth, with a favourable ruling in hand, you proceed with certainty. The tax risk removed from the decision entirely. For transactions above a certain size, that certainty is worth far more than the cost of obtaining it. Now the strategic reality that makes rulings interesting. They cut both ways. A favourable ruling is gold. You rely on it with complete confidence, and the ATO cannot change its mind about your arrangement later. But an unfavourable ruling is not simply disappointing, it is formally on the record. The ATO has now stated, in writing, addressed to you, that it will tax the arrangement against your interests. Proceeding as if the ruling did not exist is not a strategy, it is an invitation to penalties. Which means the decision to seek a ruling is itself a strategic one. How strong is your position? How would you frame the question? What happens if the answer is no? Those questions deserve the same care as the transaction itself, because once you ask the ATO, you will get an answer, and you will have to live with it or fight it. So the ruling has gone against you. What now? First, know this. A PBR is binding on the ATO. It is not binding on the truth. Where the ATO has misapplied the law or misunderstood the facts, you have a formal right to object to the ruling. The time limits are more generous than most people expect, generally the later of 60 days after the ruling is given, and the standard objection period for the relevant year's assessment. 2 years for most individuals and small businesses, 4 for others. One structural point. Once an assessment has actually issued for the period the ruling covers, your challenge must generally be directed at the assessment rather than the ruling. And the path does not end with the objection. If it is disallowed, the matter can go to the Administrative Review Tribunal, which replaced the AAT in October 2024, or the federal court, within 60 days of the objection decision. What separates the objections that overturn rulings from the ones that bounce off? Start with what does not work. Disagreement. I think the ruling is wrong is a sentiment, not a ground. A winning objection engages the ATO's reasoning head-on. It takes the ruling's own logic and identifies precisely where the law was misapplied or the facts were misunderstood, step by step. It is built as legal argument, the legislation, the case law, and the evidence assembled into a case that gives the reviewing officer a reasoned path to a different answer. And it is, frankly, work for professionals. A ruling objection is legal advocacy against the ATO's own written position. You are asking the commissioner to conclude that the commissioner was wrong. The quality of the drafting decides these contests far more often than the underlying merits do. Here is what that looks like in practice. Our client had applied for a private ruling on her Australian tax residency. The ATO ruled against her. In its view, she was a foreign resident. Applied to the sale of her Sydney home, that determination generated a capital gains tax liability of more than $350,000. The main residence exemption stripped away entirely. We lodged an objection to the ruling, arguing the ATO had incorrectly applied the domicile test to her circumstances. What followed was 3 months of detailed correspondence, evidence exchanged, submissions refined, the legal analysis pressed point by point. The ATO accepted our argument and allowed the objection in full. Her residency was corrected, the exemption restored, and the CGT liability reduced to nil. Binding, yes. Final, only if nobody fights it properly. Prevention beats dispute, and most bad rulings trace back to the application. 4 disciplines. First, state the facts completely. Omitting awkward details does not help you. A ruling issued on incomplete facts protects an arrangement that does not exist, which means it protects nothing. Second, ask the right questions. The ATO answers exactly what is asked. A misframed question produces a ruling that misses your real issue, or worse, addresses a less favorable version of your arrangement. Third, argue your own analysis. A well-supported view of the law in the application, with authorities, shapes the ruling you receive. You are allowed to advocate, and you should. And fourth, anticipate the unfavorable answer before you apply. Know your objection and review options in advance, so strategy does not begin only after the bad news arrives. The ruling is only ever as good as the question you asked. Let me close the analysis with the 3 mistakes we encounter most. First, leaving out the awkward facts. It is human to present your best case, but a ruling obtained on curated facts gives false comfort and no protection at all when the real arrangement differs. The ATO's commitment extends only to what it was told. Second, asking the wrong question. We regularly see rulings that are perfectly correct answers to questions nobody needed answered, while the genuinely contentious issue was never put. And third, treating a bad ruling as final. As our residency case shows, unfavorable rulings get overturned on objection. Accepting one without advice can cost hundreds of thousands of dollars that a well-built challenge would have recovered. Every one of these mistakes is avoidable, with care at the application stage and courage at the objection stage. At Australian Tax Experts, tax lawyers and accountants handle the entire ruling lifecycle as one team. We prepare PBR applications, the facts stated completely, the questions framed precisely, and the legal analysis argued, so the ruling you receive delivers the certainty you actually need. We run ruling objections, unfavourable rulings, challenged with proper legal argument, including that $350,000 residency ruling objected down to nil. And where an objection is disallowed, we carry the matter to the Administrative Review Tribunal or the Federal Court, with the forum chosen strategically. Whether you are seeking certainty before a transaction or fighting an answer you have already received, the earlier we are involved, the better the outcome tends to be. If you have received an unfavourable ATO private ruling, or you are considering applying for one, contact Australian tax experts for expert guidance on getting the best possible outcome. Visit australiantaxexperts.com.au/contact. Thanks for watching, and remember, this presentation is general information only, not personal tax or legal advice.